Okay, so now I want to just lay the groundwork and and teach you guys what bankruptcy is and how it works before I get into litigation of student loan debt and bankruptcy. So bankruptcy is a legal process established under federal law to allow people who can't pay their debts to eliminate or discharge the legal obligation to pay most or all of certain types of debts and obtain a financial fresh start. The foundation is in the U.S. Constitution, and it authorizes Congress to enact uniform laws on the subject of bankruptcies throughout the United States. Under this authority, Congress enacted the Bankruptcy Code in 1978. The fundamental goal of federal bankruptcy law is to give debtors a financial fresh start from burdensome debts. The purpose of bankruptcy is twofold. Just keep in mind that not only is it designed for a fresh start for the debtors, it's also designed to give a fair distribution to the creditors because bankruptcy is a court of equity. One of my favorite quotes about bankruptcy is from a 1934 Supreme Court decision, and it says, "Bankruptcy gives the honest but unfortunate debtor a new opportunity in life and clear field for future effort, unhampered by the pressure and discouragement of pre-existing debt." And I think this really encapsulates what a student loan borrower is, the honest but unfortunate debtor, someone who went into debt, to pursue higher education and, do something great and open up more opportunities for themselves, but only to wind up struggling with debt. So the goal of bankruptcy is accomplished through a discharge, and this releases debtors from personal liability from specific debts and prohibits creditors from ever taking action against that debtor to collect those debts. And the debtor is no longer legally obligated to pay any debts that are discharged. So there are two types of personal bankruptcy. Mostly I deal with Chapter 7. So the Chapter 7 is a liquidation plan in which non-exempt assets are used to satisfy debts. But most Chapter 7 cases are what are called no asset cases, meaning that the debtor's property is protected or exempt from the creditor's claims. So one of the misconceptions about bankruptcy is that the person loses everything, and that's not true. There's something called exemptions, and that protects the debtor's assets. So for example, there are homestead exemptions, vehicle exemptions, the person can have cash, retirement accounts, household goods and items. So the law is designed to protect the debtor's assets, and because otherwise they wouldn't really be able to get a fresh start, right? If they don't have a house to live in or a car to drive, how are they really getting a fresh start? So just keep in mind, for those of you who don't work in the bankruptcy space, that it doesn't mean that you have to give up everything. The exemption laws protects the debtor's assets. Okay, so moving on to Chapter 13. Chapter 13 is what's known as a wage earner's bankruptcy. So the person has to have regular income to pay a portion of their debts through a court-approved plan. So the payment plan is anywhere from 3 to 5 years, depending on how the debtor's assets and their income. So just keep that in mind as well. So one of the beautiful things about bankruptcy is something called the automatic stay. So this is what stops all collection efforts from the creditors. So all collection calls and letters must stop. Lawsuits, any lawsuit can't be filed or they can't continue while there's a bankruptcy pending. No wage garnishments, foreclosures, repossessions. So it really protects the debtor from all collection activity. It's important to distinguish the difference between dischargeable and non-dischargeable debts. So dischargeable debts are your general debts that you think of. So credit cards, medical bills, personal loans, auto loans, payday loans. Non-dischargeable debts are like taxes, child support and alimony, fines, DUI debts, and student loans.